Before we even get into the courtroom details, this case already has the ingredients for a disaster. A defendant on probation, direct court order, and a decision to ignore it. In court, probation is a second chance, but it comes with strict rules. And when a judge orders someone into a specific rehabilitation program, that order isn't optional. What you're about to see is what happens when someone thinks they can pick and choose which parts of a judge's order they'll follow. And trust me, the moment this judge realizes what happened, the tone in the courtroom shifts instantly.
Why is she not going to DDRF? That's my question, because that's what I ordered.
She did not want to participate.
All right, so you can participate at the prison, but it's not going to be at SafeP. This is not Burger King. People do not get to have it their way. I ordered DDRF, and you don't want to go there.
She violated the Judge Boyd order and thought she will get away with it, but Judge got visibly angry on him.
Court is calling 2023 CR 4230, State of Texas versus Darianne Renee De La Rosa. Could I have parties announced for the record for the state? Defense?
Charles Golden.
Are you Ms. De La Rosa?
Yes, ma'am.
Showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it? Are you the same Darianne Renee De La Rosa who was placed on deferred adjudication in 2023 CR 4230?
Now here's where the legal stakes become very real. The defendant was originally placed on deferred adjudication for robbery, which essentially means the court gave her a chance to avoid a formal conviction if she followed every rule of probation. But when someone violates probation, especially by ignoring a court-ordered treatment program, the judge has the authority to revoke that deal entirely. That means the case goes back to square one, and the judge can sentence the defendant as if the conviction just happened. In other words, the safety net disappears instantly.
0 for the offense of robbery on July 17, 2023 for a term of 5 years. Is that you?
Yes, sir.
State?
Yes, Your Honor. Violated condition number 56 on or about the 30th day of January 2024 in Bear County, Texas. The defendant, Darianne Renee De La Rosa, then and there failed to comply with the rules and regulations or instructions of the Bear County Supervision and Corrections Department. Duly diagnosed residential facility, and the defendant refusing to participate with the required program by the number 56.
How do you plead to that? True or not true?
True, Your Honor.
Did you understand by pleading true to violation of 56, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, sir.
Knowing that, do you still wish to plead true to violation of condition 56?
Yes.
Court will find it true. Is there a proposed agreement?
There is, Your Honor.
Yes.
It is to keep the individual on her probation and defer to deny motion and alter and amend require her to attend safety.
This is the moment that really lights the fuse in the courtroom. The judge had specifically ordered the defendant to attend the DDRF rehabilitation program, but instead of completing it, she simply refused to participate. And from a judge's perspective, that's not just a small violation. It's direct defiance of a court order. When the judge says, "This is not Burger King," that's not just a joke. It's a warning that the court system doesn't operate on personal preferences. Orders are orders, and when someone ignores them, the consequences can escalate very quickly.
Okay, why is she not going to DDRF? That's my question, because that's what I ordered.
Your, the information that was received from DDR was she did not want to participate.
All right, so you can participate at the prison, but it's not going to be at SafeP. This is not Burger King. People do not get to have it their way. I ordered DDRF, and you don't want to go there. So what's going to end up happening? You've been here before. The court is going to find you guilty.
At this point, things are getting serious. The judge is now deciding how much prison time to impose, and the numbers being discussed aren't small. The prosecution is asking for 5 years, while the defense is hoping for just 2 years and another chance at treatment. But the big question is whether the court believes this defendant deserves another opportunity at all. Let me ask you, if someone ignores a direct order from the judge, should they get another chance? Or should the court make an example out of them? Let me know what you think.
Now, how much prison time do y'all want to ask for?
Judge, the state is additionally maybe requesting 5 years, Your Honor.
I would ask for two, Judge. She's willing to go to safety. She wants to continue with drug court. We would ask that you reconsider and consider safety. We understand that's going to be 9 months long with aftercare. She's willing to do that.
Okay, this is what the court is going to do. As previously stated, the court is finding violation of 56 true. The court.
And just like that, the judge makes the decision. 8 years in prison. That's significantly more than what either side requested. Judges have wide discretion when probation is revoked, and sometimes they use that power to send a very clear message. Ignoring a court order has consequences. What makes this moment so powerful is that this entire situation could have been avoided if the defendant had simply followed the original program the court ordered.
Court will find you guilty. There is to be no contact with Monica Tobias. Court is going to find you guilty. Court is going to sentence you to 8 years in the prison. Court will give you credit for any time served. Court will retain jurisdiction.
Thank you, Judge.
All right, I'm showing you what's entitled, showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? All right. Because this is not a plea bargain agreement, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you are on probation. Do you understand? All right, we can go off the record. So, Ms. De La Rosa, when you're sent to certain programs, I'm not just doing it because, hey, let's just do this for no reason whatsoever. There was a reason you were sent to that program. You do not get to write your own programs. If you could write your own program and be successful at it, you wouldn't be in court. You would be successful. All right, good luck to you. Court is calling 2023 CR 0292, State of Texas versus Christian Angel Segovia. Could I have parties announced for the record for the state?
Jason Gearhead, Your Honor.
Defense?
Bridget Gossip for defense.
And are you Mr. Segovia? Going to show you what's entitled motion to enter adjudication of guilt and First Amendment motion to enter adjudication of guilt and revoke community supervision. Did you review those with your attorney? Did you understand it? Are you saying Christian Segovia, who's placed on deferred adjudication in 2023 CR 0292 for the offense of aggravated robbery on May 4th, 2023 for a period of 10 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor. Violate condition number 1 on or about the 18th day of January 2024 in Bear County, Texas. The defendant Christian Angel Segovia committed the offense of possession of a controlled substance relating 1 in violation of condition number 1.
How do you plead to that? True or not true?
General waiver made violation.
Any objection?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 1? Court could find it true, grant the motion, find you guilty, sentence you up to life in prison and up to a $10,000 fine? You need to speak up. Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
It is not an agreement, Your Honor.
All right, state, what are you requesting?
States requesting revocation, Your Honor.
All right, defense, what are you requesting?
Judge, we're asking the court to follow the recommendation of the probation department. The probation department is recommending, give me a moment, Judge. The probation department is recommending to amend the conditions for state ISF, a cognitive track, biweekly drug testing for 60 days upon his release, and ZT probation.
All right, I don't do zero tolerance probation really because this is zero tolerance. This is your first motion to revoke. You want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record.
Christian Angel Segovia.
All right, you're going to need to speak up and speak clearly.
Christian Angel Segovia.
Just when you think the courtroom drama is over, another defendant steps forward, and this case raises an even bigger question. This time, the charge involves aggravated robbery, which carries extremely serious penalties, potentially even life in prison. But instead of defiance, This defendant claims he's struggling with homelessness and addiction. Now the judge faces a difficult choice: punishment or rehabilitation. And as you'll see in a moment, the judge is about to challenge him directly about the decisions that led him here.
All right. Why are you not successful on probation out of this court? No.
Drug addiction.
Let's backtrack. So they're saying you picked up a possession case. I'm able to see everything in the motion to revoke, not considering it, but I'm only considering what the state is going on. So I'm trying to make a determination of whether or not you should be going to prison for life or 5 to 99 years up to life. You understand? So what is going on with your life, and why can't you complete this probation successfully?
I'm struggling with money, and I'm struggling with to live. Struggling to take care of my family that I have.
Well,
I need help though.
here's the thing. A lot of people struggle. A lot of people have issues with their finances. If your problem is a money problem, I'm going to tell you what my mom always tells all of us and what her mom told her. If you have a problem that money can solve, that's not a real problem. A real problem is when you have a problem and money can't solve it. For example, just a hypothetical. If you have cancer and the doctor tells you it's terminal and you say, I have $2 million, will that help? And they say no. That's a problem that money can't solve. You understand? So you saying that you have a money problem, that's not a real problem. It's not a problem that should cause you to pick up a new offense. How old are you?
No.
Do you want to go to prison and spend your life in prison?
No.
Then you had better get your life together. I see that probation is recommending the ISF track. I'm going to give you a choice because I don't think the ISF track is enough for you. They're saying that you have not reported. They said that they tried to do field visits at your home and you were not there. So that tells me there are some major issues with you.
Judge, if I may,
Yes.
part of the issue with Mr. Segovia is that he's homeless. He became homeless, compounding the fact that he has a drug issue. He's asking the court, he's begging the court for help. He admits that he has a drug problem. Because of this drug problem, he obviously committed a new offense. He's not hiding it. He didn't deny it. He's here before you asking for help. He's 22 years old. I think he deserves an opportunity to get some type of inpatient treatment before sending him to TDC and saying goodbye, see you later, figure out in TDC.
I mean, I'm going to give him a choice, but your choice is not going to be ISF. Your choice is either going to be SafeP or either you're going to prison. SafeP is a treatment program, but it's at the prison, but you're not in general population with other prisoners. So your choice is either you're doing SafeP for your drug issues or either you're going to prison. Which do you choose?
Safety.
All right. I'm going to deny the motion, alter the main conditions to include SafeP and probation. I don't believe drug court is going to accept him because of the nature of his charges, but I'm going to ask for felony drug court as well. You can, counsel, if you want to talk to felony drug court and explain to him why this may or may not be a good fit for him. And then we're going to do, once he's released, I am going to want field visits. 1 time per month until further notice. And the UA hotline. And he's to remain in custody until transferred to SafeP or felony drug court. Is there anything else you need from the court to be successful? All right, so when the time gets long at the jail because you're waiting for transfer to SafeP and you want to come back to the court and say, I've been at the jail for 3 weeks, just remember that You were begging me for help, and you could have ended up going to prison for up to life. You understand? Off the record, here on out, everything that you do, you need to ask yourself, is this something that could potentially result in me going to prison for life? If the answer is yes, don't do it. If the answer is maybe, don't do it. And everybody knows.
This is a tough lesson in listening to the judge. We're in court with Darien.
This courtroom session highlights two very different outcomes under the same justice system. In the first case, a defendant ignored a direct court order and ended up receiving 8 years in prison after her probation was revoked. In the second case, the judge recognized a serious drug problem and gave the defendant a chance to enter a structured treatment program instead of going straight to prison. It's a powerful reminder that probation is both an opportunity and a responsibility, and the choices people make while on it can completely change their future. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.